conflict scenarios. We've done current representation conflicts in 1.7, and now we're doing 1.9 formal representation, but we're sort of looking forward and backward at the same time. We'll see that when we do the hypos that we're going to work on today. But I just put some of the major terms up on the board that we have been looking at. And we have been looking at this concept of formal representation. And so we're looking at successive conflicts, they're often called, or subsequent conflicts. We have a present client that we're representing currently, maybe a prospective client, and we're doing something currently that impacts something that we did in the past, that formal representation. And so when we evaluate that, we have to look at what we're doing now and what impact that might have on something in the past. Because even though that representation has ended, our former client expects that undivided loyalty that the attorney owes to the client. And so we started looking at Rule 1.9. And 1.9 tells us that we have this continuing duty to a formally represented client. So we formally represented this client in the matter. We shall not thereafter represent another person in the same or substantially related matter. Which is really just a way of saying we don't want you to undo what you did in the past for this former client. So you prepare a will for an elderly man and set it up very nicely. He passes away, and then the son says, okay, I want you to undo the codicil that he put in there. So that's clear conflict. Of course, you couldn't do that because you're working on the same matter to undo that will that you did before. You can't say that the person passed away, therefore the representation is terminated. You still have that continuing duty to the estate and everyone else who relied upon that. So that would be the same matter. Substantially related is something that we have to really look at and try and figure out. We have it in the book. It's something that could be related to what we are doing presently. So that may not be the exact same thing, but there is some type of overlap, some type of commonality that we're trying to identify. So we'll look at that. So one thing that I emphasize is, apart from the continuing duties to a former client, which is in comment 1, we also noted that there is a presumption in Rule 1.9a. So that presumption serves a purpose. We don't want the former client to have to reveal actual confidences. And we look at this conflict in 1.9a as confidential information that a lawyer normally would obtain in that type of representation. And so we're looking at that. And then is it materially adverse? We compared that with directly adverse, which is a lot broader, stricter. Materially adverse is something that goes to the disadvantage of the former client, undermines the former client's interest. So that's 1.9a. What type of information? In a representation. I'll put normally obtained. So in this line of practice, you're saying that this is the type of information that the lawyer would come across. So there's no movement there. We just have the scenario where a lawyer in a firm previously represented another client. Again, we look at whether or not this current representation conflicts with the former representation. Materially adverse to the interest of the former client. And then there's always this notion of informed consent. So the former client can always give informed consent. That doesn't mean it always happens, but it can. So moving down to B, that is a different situation. Lawyer moves. Lawyer shall not only represent a person in the same or substantially related matter, same type of language, in which a firm with which the lawyer formerly was associated. So I've gone from this former firm to my new firm, and now I'm doing something currently that may impact the work that I did at that former firm. Now, look at the language. Comment. We're talking about actual knowledge here. Actual knowledge. So a higher standard when a lawyer moves to another firm. Is there. And that's an important distinction. That's an important distinction because we're trying to balance a number of things. And if you look at comment 4, even before that, it tells us what we're trying to do. We're trying to do 3 things. Really, we are trying to make sure that this client previously represented by the former firm is reasonably assured that the principle of undivided loyalty is recognized by the attorney. So don't be fooled by, oh, this person is no longer the attorney here. There is still this notion of undivided loyalty. So we want to preserve that first and foremost. Secondly, the rules should not be so broad that it precludes other persons from having a reasonable choice of legal counsel. So we don't want this to be so rigid that, oh, as a former conflict, you can never represent this person. Client may want that type of representation. So we want to preserve undivided loyalty while at the same time preserving the client's right to choose. And then finally, the rules should not unreasonably hamper our movement. We should be able to move to different firms and not be precluded from pursuing our livelihood simply because of something that we did in the past. So third, the rule should not unreasonably hamper lawyers from forming new associations and taking on new clients. So we're going to do some imputation here. That's what I want to emphasize. Comment form in that regard as well, because it says this. If we apply this rule very rigidly, if the concept of imputation were applied with unqualified rigor, the result would be radical curtailment of the opportunity of lawyers to move from one practice setting to another, and of the opportunity of clients to change counsel. So we want to preserve undivided loyalty, we want to give client choice, we want to allow lawyers to be able to move from place to place. Nothing wrong with that. And that's why we have a higher standard here, actual knowledge. So the question changes when a lawyer moves from one firm to another from what type of information would the lawyer normally obtain in the representation to actual knowledge. You see that in comment 5. So that's what we get. And then we got up to, we're going to do toxic waste on page 345. But the very first problem on page 343, we said keeping in touch. And you know that keeping in touch was just a little simple hypothetical to allow us to work through the rule initially, to see if something that we did in the past conflicts with something that we're doing currently. And you saw in that case work done 5 years ago, the work was discrete, took place only one day. Some continuing newsletters, that's in there to sort of lead you down the path of saying, oh, this is representation, but not really. The former client, in quotation marks, always declines our offers to work on different matters. So really this former client on some level just gets newsletters. And you see on page 343, your preliminary review suggests that the only problem relates to the firm's previous work for Allman Enterprises. Very limited discrete work. We need to evaluate whether Allman is a current client. Because if Allman is a current client, 1.7 applies, and that's a lot stricter than 1.9. So we always have to ask in these conflict questions, who is the client? What is the relation to the representation? Make a determination as to whether 1.7 or 1.9 applies. 1.7 directly adverse, and remember we underscored the point that even unrelated work could be directly adverse. But that was not the case here. Allman was not a current client, and then it says if you decide Allman is a former client, would 1.9 permit you to represent Star? And we said yes, and we just went through our checklist. Not the same matter, not even substantially related. You just have a series of newsletter contacts. You have Allman always saying we don't need your services, and there's nothing materially adverse. So you would be permitted to represent Star against Allman, former client in quotation marks. So the next section starts with dealing with former clients in practice. Now this is an actual case. Happened not that long ago, 5 or 6 years ago. And toxic waste, problem 8.2 on page 345. So, how are we going to break this down? So we're going to use everything that we talked about thus far in terms of former clients and apply it in this case to figure out the representation. And this case is deliberately tricky because I think lawyers in practice oftentimes say, well, that was 20 years ago, no big deal. Well, that was 5 years ago, no big deal. The representation ended, there's nothing ongoing, and I'll just use common sense and there's no conflict. So what we're trying to emphasize here is always go to the rule and look at the factual situation that you're in. Because the passage of time may not do anything to this information, and we have to figure out all of these relationships. So, starting with this problem, toxic waste. I guess the state wants to hire our law firm to initiate a lawsuit, state against NCC, major chemical manufacturer. It's environmental litigation, and our firm is, this is the proposed lawsuit. Now, instead of me sort of going through these facts, I want you to sort of tell me what things jump out at you that might make our former representation a problem. So we start with this firm formally represented NCC 20 years ago. So you might say we're home free 20 years ago. It's almost a generation. It is a generation. So we are in the state. We have specialized expertise. We do environmental resources work, specialized expertise. The state always contacts us as a matter of our expertise, and we're economical because we have contingent fees, which saves the state a lot of money. They don't have to use the Attorney General's office or state attorneys to do this work. They partner with us, and they get a good deal. Contingency fee plus our great expertise. We brought lawsuits, and we are generally always successful. Never lost a case that goes to trial. Now, this proposed lawsuit, the state wants us to take on a big case against NCC, a multi-billion-dollar chemical company, alleging that NCC has dumped insufficiently treated chemical waste in one of the state's rivers. So they're dumping and dumping. NCC, of course, says nothing of the kind. We comply with all EPA regulations, all state regulations, all county regulations. No problem here. So identify the factors that might cause this to be a former conflict. What things in the facts do you see that we should be looking at before we go through the case? So I want this is like to be real life. It's, we just got into the office. We've answered all our emails. We checked over the memo that we're drafting. That's pretty good. Now it's like 10:30, and we start get a call from our supervising attorney. Says, I want you to take a look at this. He sends us this over email, and he's giving you all this background that I've already talked about. Now your first step is to analyze the factors that could make this a former conflict. And after we identify that, then we have to figure out what can we do about it. So what factors are you looking at? Yeah, go ahead.
I think it's something to note that even though you represented NCC 20 years ago, it's only been 10 years since they discontinued using the whatever it was that you helped them be able to use in the first place. So it's more recent than what it actually.
Okay, that's interesting. Yeah, more recent. That's good. And so, how does that impact your analysis?
Well, I think it's harder to fully move away from it. It was just 20 years. It was 20 years ago. As we read on, a lot of people that had to deal with it were gone or passed away or retired. But when it takes 10 years, it makes it more recent. There's probably more people that were involved 10 years ago than there were 20 years ago. Okay. So that's an interesting twist. Is this work current enough to cause a former conflict? Very interesting. That's good. Anything else? So what we're talking about is, you see on page 346, NCC stopped using chemicals in food wrapping, but started using chemicals in other products, and that was 10 years after the FDA approval. What about our work? You're doing two things when you analyze these former conflicts. You're looking at relationships between entities and clients, of course, but you also have to look at our work. What about our work? Yeah.
We in the past helped them gain approval to use fluorochemicals. Now that's the exact issue that we're able to try to wrap them on.
Okay, help gain an FDA application. I'll just put fluorochemicals, and there is overlap. proposed lawsuit. Good. So notice how the facts are, we did FDA approval. There's been a shift in terms of how this information has been used, but NCC is still using this chemical. So that's the problem. NCC, you see the top of page 347, discharges into waterways, but they claim that there's no significant environmental hazard because we use effective treatment techniques and comply with all regulations. That's what FCC wants to say. Anything else? So we talked about the nature of the matter. It's not 20 years, maybe it's still current. We talked about our previous work. We helped gain approval in FDA application for fluorochemicals. And there's overlap between this and the proposed lawsuit because the lawsuit alleges that NCC continues to dump fluorochemicals into the state waterways. Anything else? What about more about the nature of our work? Think about what about motion practice? One question you have to ask yourself: what will discovery mean in this case? Just because something is 20 years old or 10 years old, we may uncover something that would be information under 1.9c that would be to the disadvantage of a former client. So that's something we have to keep in mind. What about, let's go inside the firm. Let's talk about Max Freeberg and Ellen Peschel. What about that? What about Max Freeberg? Yeah.
He retired, and everyone else that's worked on it either left the firm or still does tax litigation.
Okay. Be careful. That's good. Let's back up, though. Let's talk about what type of work Max Freeberg did. What did he do? So I'm trying to get a sense of what type of knowledge is flowing through the firm. I'm putting quotation marks flowing through the firm, but you said that pretty much everyone is either retired, Max passes away after he retires. But we're going to come back to Ellen Peschel because she's still around. She was around 20 years ago. She's a first-year associate. Now she's a partner. And we have to look at her work as well. What about Max Freeberg? Yeah, go ahead.
He studied the reports at the time when they were preparing that application.
Okay.
He's never went public with anything.
I'll say that again.
He never went public with anything to review.
Okay. Studied all reports and what FDA application. So that's chemical reports, analysis, company memos, everything that would help us get FDA approval. Information is not public. Notice this, information is not public. And notice what that means. NCC in the litigation is going to, NCC will claim trade secrets. That's it. So we have I'll just put it, retired, passed away. So notice how this problem sort of entices you to say, oh, that's not a problem, Max is gone. But you always have to look at the information that the firm might have. So you see on the top of page 347, it is highly likely, given industry standards and the company's press releases over the years touting its engineering and legal research to ensure compliance, that NCC chemists studied the toxicity of fluorochemicals and the effectiveness of various waste treatments even before NCC started making a food packaging product. That's going to be interesting about. Notice what did NCC know, and then what is our relationship to that information. And that notice that Freeberg have reviewed those studies. And as we just pointed out, NCC has never made the results of that research public. And they would probably claim trade secret. So Max Freeberg is no longer there, but we have Ellen Peschel. Now, she was a first-year associate. So she did work on it. Now, a partner. I'll just put can't remember. Can't remember details. She remembers working on it, but that's about it. And so, you see this is on page 347. Firm, also, notice this. Firm has no records. Records are destroyed after 5 years. And then the only document that we have is the FDA application is a public document. So now what? Now what? So everybody's gone. The only person that's still there is Ellen. She was an associate, did work on it, can't remember all details. But she does remember something that's important. What does she remember that might cause us to be worried about a conflict? Yeah.
So what I said about Pascal was that she does remember the people within the company.
Uh-huh.
She disagreed about the effectiveness of waste treatment.
Uh-huh.
So if this is generally known, then you can still use that information. But if it's not, then that's a protected information.
Oh, that's interesting. And wait, tell the person who's like generally known.
So
and then if it's not known.
if it was generally known outside the company and representation that people within NCC disagree about the effectiveness of waste treatment on a more project as well. Yeah, it's generally known that you can use that.
Because you're not hurting anybody's out circulating. It's in the courier journals and trade journals. There have been protests, there have been rallies, everybody's talking about it, that's fine. And so that's more like public information, it's out there. Now, what about this internal thing you're doing? That's interesting. If it's not known publicly.
Yeah, if only people in the company or in the firm knew that people within the company disagreed about the effectiveness of the fluor chemicals, then you can't use that information directly first.
Okay.
And protect it under 1.6.
Okay. So she doesn't remember anything, but she does remember that some within the company disagreed about the effectiveness of NCC's waste management. In other words, there was a compliance issue when we did this FDA application. Doesn't recall any details. So everybody's gone away, and we have this this one tidbit of information. So this is what we've done thus far in our analysis. Now we have to figure out what can we do. So you see the bottom of page 347. May we accept the Attorney General's invitation to represent the state in this litigation? So it'll be us against the former claim. How do we analyze this under 1.9, and can we take on this representation? May we represent the state? So, I think we know this is not the same matter, but we definitely have some problems with substantially related. Why do I say that? So, can we jump in and say, okay, we represent the state against NCC? And another thing I'm highlighting, this is not really in this problem, but another thing you have to think about is maybe the former client doesn't give consent. Maybe because it's a former representation, we do something called screening that might help do all of the steps. But then there's always the possibility of a motion for disqualification. Remember when we first started the class, there all of this law that you have to look at. You have to look at, of course, the Code of Professional Responsibility, but there are other things that govern our conduct. Rules of procedure, disqualification law, ethics decision. So can we represent the state? Yeah, it's 20 years ago. This represents. And if that's the case, what do you think the former client might say? Yeah, go ahead.
I would say no, we can't represent the state in this case because looking at 1.9a, the matter is substantially related and it would be.
Okay, good. Yeah, break it down for us. So tell us, why do you think that this is substantially related? I think you're right. I just want you to point to what you're looking at.
The main thing for me that stands out is that it's the same, like the fluorochemicals are the main issue here, which is what the firm helped them on before. So to me, that makes it substantially related.
Okay. So notice, we're saying that the subject matter is the same. Maybe in a different context. One, we were doing some compliance issue, administrative law, FDA, all of that. Now we're doing an environmental litigation, but the key component that unites both of those scenarios, both of those matters, is fluorochemicals. So what we did before involved fluorochemicals, and this litigation will deal with compliance fluorochemicals. So there's some type of analysis. Okay, keep going. Yeah, that's good.
And then I think that the interest of the state, which would be our client in this situation, would be materially adverse to NCC because obviously NCC wants to continue their use of fluorochemicals, and the state would want to control that, so that would be adverse.
Now that's good. Now look at that. So we don't really have a definition of what materially adverse is, but we know it's something that goes against our former client's interest. And this certainly would. We'd be going against our former client and saying that they didn't comply. On some level, undoing, in quotation marks, what we did previously, because we were vouching for our client NCC 20 years ago by saying they fully complied, they're entitled to this FDA application. There was some dissension within the firm. Within the company, disagreeing about the compliance, and the lawyer knew that. But what about this, Ms. Boyd? What about this? It's 20 years later. The primary attorney, Max Freeberg, has passed away. And even before that, he retired, so he gets further away from this information. Alan Paschal can't remember anything, just that there was some type of argument. And so, could we say that all of the damaging and disadvantageous information that would hurt our former client has really left the firm? So, since that is the case, we can represent the state. What do you say to that?
I would say no, just because the rule doesn't address the time constraint. I was trying to look through the comments because I thought I saw something about how things could expire over a certain time, and that might have been in a different rule. I don't remember, but the rule itself doesn't say anything about time. But I think those factors about how it has been 20 years and the same attorneys don't work there anymore could go into a conversation about informed consent for NCC if you were interested in representation. But I don't think we could, without informed consent, represent the
Okay.
state.
And I don't think we're going to get informed consent, really, because of our relationship. So that's good. I think you might be referring to, we haven't done imputation yet, but maybe if everyone leaves the firm, that means that the taint of the conflict isn't running through the firm anymore. If there's no one left with the firm who still has information that could hurt the former client, the firm can then represent, even though it is against the former client's interest, because there's no information in the firm to hurt the former client. So that's interesting. So what do you think happened in real life? This is a real. Okay. So notice, and I think most courts will do this before we get there. The fact that we say that Alan really doesn't remember, that's going to be irrelevant to us, because notice what Ms. Boyd did. She looked at 1.9a, and there's that presumption of what type of information that the attorney would normally obtain in the representation. And NCC is going to come back and say, well, they knew everything about us. It's 20 years later, but we're still talking about fluorochemicals. There may have been advances in technology, certainly, but these basic principles in our documents is something that is in the knowledge of the firm. So even though the firm has no records, there is a public document out there, and someone could conceivably interpret that public document based upon information received from the former client. So what do you think happened in real life? In the real case, I should say. The real case is like Minnesota against 3M, Minnesota Manufacturing and Mining. What do you think? So the court really didn't totally resolve the issue. But what do you think happened? Yeah.
I would assume they tried to do that as a representation mistake, and the court ruled they couldn't after ETC or whoever the real person was who happened.
Yeah, I kept hearing about disqualification. So this is state against 3M, Minnesota against 3M. And so the firm was Covington and Burling, and 3M moves for disqualification. The trial court disqualified Covington and Burling as violating Rule 1.9. So it then moves up to the Supreme Court of Minnesota, and they did something interesting. I don't know what happened, but they remanded the case on 2 points. One, and this was interesting, one is, has this confidential information become public in 20 years? So that's interesting that we even had that discussion, because that's one of the things that the Supreme Court remanded on. So did this information become public? And then there's another little wrinkle that isn't in these facts, but that happened in the real case. 3M waited a long time. So sometimes entities or firms or clients will wait, and then they file a motion for disqualification, sort of like a strategic tactic, and that was a problem. So the court said that 3M waived its right to claim disqualification by waiting until the firm has spent so much time and expense on the case. So that's toxic waste. So we've done 1.7, we've done 1.9, we keep looking at those two together. Now we look at Rule 1.10, imputation. So I want to know how 1.10 works. What is this concept of imputation? Now we've seen this before, when I mentioned that the conflict really travels through the firm. We are one lawyer for conflict purposes. And so we have to figure out how imputation works. So I want to take apart this rule piece by piece and then figure out. So, imputation. So, we want to break this rule down. We're going to look at 1.110a. How does this rule work? Imputation. Real quiet. Let's see. Ms. Burns. Now, let's break down the rule piece by piece and we'll talk about it. Go ahead.
So basically, if lawyers are associated in a firm, I think none of them will knowingly represent a client, but they kind of, none of them will represent a client. When one of them practicing alone would have a concurrent or former conflict with them.
Okay, good. That's just a paraphrase, but we are one firm. And if one of us has a current conflict or former client conflict, we cannot represent. While lawyers are associated in a firm, we're all together, this is our firm, none of them shall knowingly represent a client, but any one of them practicing alone will be prohibited from doing so. By current conflict, so maybe I'm representing somebody and I haven't really checked correctly and I have this conflict. So everybody has that conflict. Or I don't have a current conflict, but I just moved over from another firm in room 171. I moved from that firm to this firm. I currently represented someone in 171, and that was the former representation, but I bring something with me that conflicts with that. There may be information that this firm could use against the matter in 171, and then that conflict would travel throughout the room. We are one lawyer for conflict purposes. So a lawyer shall not knowingly represent a client when any one of them practicing alone will be prohibited from doing so under 1.7 or 1.9 unless. So unless what? Ms. Barnes, keep going.
So unless the provision is based on personal interest of the qualified lawyer.
Okay. So what do you think that personal interest is? So this is interesting. There might be something singular to me that could ostensibly look like a conflict, but it doesn't travel through this room. So say we're a big-time constitutional law firm. We do First Amendment work, 14th Amendment work, all levels, state and national practice. And the firm, like the ACLU, sort of embraces free speech absolutism. We want the marketplace of ideas to flow completely. The firm at a meeting, I'm one of the partners in the firm, law partners, we have this discussion, and the firm outvotes me and they say, we're going to represent an organization that is against equal rights. Anything that says equal rights, this organization is against it. And so we choose to represent them because they give speeches across the country, and we want to make sure that the content of their speech is not undermined by the state. So First Amendment is what we are representing. Not representing the client, not advocating for their particular viewpoint. my firm has this broader view that we have to represent this organization in order to advance constitutional ideals. I hate this organization, and I'm really angry at my partners, and I say, I'm not going to participate in this. So that wouldn't run through the firm. They would just keep me away from it. I'd get no fee. I would just not participate. But that's my personal interest. And so that isn't going to affect the firm. And so they would certainly keep me away from it because I wouldn't be able to give the competent and diligent representation that is required. So that's the personal interest of the disqualified lawyer. And it doesn't present a significant risk of limiting the representation of the client by the remaining lawyers in the firm. Now, if I say something like this, okay, I'm the major managing partner. If you take this on, I'm going to make life difficult for you. I'm going to reassign your research team. I'm going to not give you enough money. I'm going to talk against it out of the law firm. Any junior associate who works on it, I'm going to give them a bad job. That would be totally disruptive, and that would be a real question about materially limiting the representation. But if it's just a personal interest, that attorney, the disqualified attorney, just wouldn't participate, and that would be fine. So that's personal interest. Or, what does 2 say? So with one lawyer for conflict purposes, if we have a current formal conflict, it runs through the firm, cannot represent it. If one of us singularly cannot represent, personal interest is not a disqualifier. So what does 2 do? I'll just put the entire. The prohibition. Base. So this is the former conflict, 4B. It arises out of the disqualified lawyers association with a prior firm. So that's the scenario where migratory lawyer comes over to this new firm, brings something with him that conflicts, and the whole room now shares my conflict that I brought with me from room 171. So this former client representation, based upon my association with the former firm, causes a conflict to run through this room. It's imputed to all of us. And so even though conflicts are imputed based upon 1.7 and 1.9, the firm is not precluded from doing it if it's just a personal interest, or if the lawyer moves from one firm to another, it arises out of my previous work. Tell me about little number 1 and little number 2. What can I do if I come over to the firm from room 171? I have this conflict. Conflict is running through the room because you share my conflict. What can you do then so that we can still represent the current client, even though we have this former client conflict? What can we do? That's what I can tell.
Assuming the disqualified lawyer from being able to access any of the records or information about the representation.
Okay. So if you look at this, we want to sort of contain this conflict. So we put up a screen, timely screen, from any petition. So notice this, you go through this rule, and you sort of, if you had to write a letter, you can just track the language of the rule. So we have attorney, he moved over here, we're aware of this conflict, this is what we did. And so notice, we're not even asking for consent. We're saying we took action in screen. And we're allowing you to comment on it, but this is what we did. So disqualified lawyer of the timely screen. Timely screen, disqualified lawyer from any participation in the matter. I'll just put no money, no fee. So you're not working on it, you're not deriving any benefit from it. And notice all of the steps. Written notice. So we want this to happen quickly. Timely screen, written notice, promptly to any affected client. Former client, I should say. So notice, this is in the rule. When you give written notice promptly to the affected former client, you want to enable that former client to make sure that you are actually complying with the provisions of the rule. And so notice this small Roman numeral 2 up here has a lot of components that have to be in this written notice. So you tell them, yeah, we set up the screen, but this is how we do it. Description of the screening procedures employed. So there should be some language that timely screen, no participation in the matter. You might define what no participation means. No fees. A statement of the firm and of the screen lawyer's compliance with these rules. So we have the disqualified lawyer sign this letter as well. And a statement that review may be available before tribunal. So notice you're inviting the former client. If you have a problem with this and we can't resolve it to your satisfaction, you can move for a motion to disqualify. And agreement by the firm to respond promptly to any written questions or objections by the former client about the screening procedures. So you might be able to resolve this through the written notice. This is what we did. Former client comes back, oh, I don't like that, could you do this? And then okay, and then that's fine. But there always is the possibility of a motion for disqualification. So timely screen, written notice. Make sure you follow all the details. I won't put them all on the board because they're in the rule. You can just look at the rule. Follow all steps. And then, there's one more component. So your timely screen, written notice, and certificates of compliance. Certification of compliance. So you're affirming that you read the rule, you analyzed the conflict, you saw that the conflict existed, you took timely action, you responded by telling the former client that this was going on, allowed the former client to protest or ask any questions, and then you certified that you complied with these rules. So we provide that to the former client. by the screened disqualified lawyer and a partner of the firm at reasonable intervals upon the former client's written request and upon termination of the screening procedure. So constant contact. We complied, and then there is this mechanism for continued compliance and communication with the former client. Now, someone tell me what 110B means. This is sort of the scenario when we had Friedberg passing away after retiring from the firm. Then the question is how much information is left with the firm. Look at 110B. So you have a lawyer terminating the association with a firm. The firm is not prohibited from representing a person with interests that are materially adverse. Materially adverse to the former client, unless the matter is the same and substantially related, and any lawyer remaining in the firm has information protected. Rule 1.6. So in our hypo, if Friedberg passes away, doesn't have any information, and maybe Paschal, she leaves the firm within a certain time, then there's no more information with the firm, and that firm can continue the representation, even if it's materially adverse, because there's no information to disadvantage that former client. We'll be going against the former client, materially adverse, but there's nothing to disadvantage or hurt that client. If you look at principles of disqualification, notes 2 and 3, sort of summarizes what I just said. This disqualification can be waived by an affected client. And then the rule just says a final thing that we're going to talk about when we talk about former client conflict is the revolving door. When an attorney goes from private to public practice and public to private. We'll talk about that. That's going to start happening more and more as we move towards Thanksgiving. People will be moving in and out of the administration. It happens every year and a half before a major national election. So that's imputation. So, in the reading talks about that. If you look on page 354 to 355, that chart, that's what we just did. So most of these imputed conflicts can be waived, you see in the rule. And that's comment 6. That's what we did. But look at a brief consultation on page 361. This is another problem. So this is designed to, this problem is designed to give us some practice with imputation. So we still keep 1.9 in your mind, but this next problem is going to make us unpack how imputation works. So we still have this rule, and we now have a procedure where even though a former client conflict may exist, we have a procedure that allows us to continue with the representation even if we don't get informed consent. Because remember, when we're looking at Rule 1.10, what we did was say, well, there is a prohibition based on 1.9. It arises out of the lawyer who moves over former representation. We pinpointed that conflict, county screen, gave written notice, certificates of compliance. That allows the former client to protest or ask questions, and maybe we can move this on without a motion to disqualify. But here on page 361, a brief consultation, another actual case. So we're dealing with still imputation. So here we have a situation where we are a partner at this firm, Shoemaker and Western. We have a client, which is Summit Bank. And there's ultimately a dispute. In a previous capacity, Lavelle, who is our partner, provided advice on tax matters to Hatley as a tax consultant to the law firm Davies & Davies. So lots of information shared. And then Lavelle moves from Hatley to become a partner at Shoemaker and Watson. She did tax advice work for Davies when she was formerly at the other firm. And so notice on page 362. After they identify this former representation conflict, Lavelle, who was moved over, explains on the form that there had been work that she did a year earlier for Davies & Davies as a tax consultant, work that may conflict with what they're doing now. So this is on the middle of page 362. She explained on the form that a year earlier, Davies at the John Davies firm had contacted her at Hartland & Lavelle to retain her for some expert tax advice. She agreed to do this work, so she gets copies of correspondence between Hatley and the bank. This is the dispute. She explained what she thought about them. She gets information about the type of suit, negotiations, that type of thing, what type of defenses the bank might raise, and how he would respond to those defenses. Now, Lavelle, after she moves, she works for Shoemaker and Watson. And so the question is Hatley a former client? Look at this engagement letter. Does that raise any flags? Lavelle does research, and she says this, tax research. We will assist your firm in reviewing income tax issues relating to the Hatley Farm suit against Summit Bank and such other matters as are agreed to in the future. So that may be a continuing relationship. So we have this. The proposed litigation is Hatley against Summit Bank. Davies & Davies is the firm. Lavelle provided advice on tax matters, and then moves to Shoemaker and Watson. So we have this engagement letter. Lavelle did some research on tax issues that would arise in settlement or judgment. She sent an email to Davies about her conclusions, and Lavelle said that Davies had informed Hetley, the owner of the firm, that she was consulting on the case and would provide assistance as needed. So Davies informed the client of Lavelle's continuing role. I'll put a question mark. Engagement. That's going to be key. So we're concerned about this. She did previous work for someone that we are now suing. That's not suing us. We're on the other side of the bid. So on page 363, aside from this consultation, the Davies firm requested no further services from Lavelle. Money is paid, you see, and that's that. Now, Shoemaker and Watson learned these facts about a week before Lavelle began her work. And as soon as she arrives at the firm, we implement a screen to prevent anyone in the firm from talking about the Hetley litigation with Lavelle. We send an email, and we also send a letter to the Davies firm.